The impacts of climate change are all around us. Worsening hurricanes, raging wildfires, and rising sea levels, just to name a few symptoms of a warning planet approaching a point of no return. We find ourselves asking the question, what can we do as future lawyers to address this? What role should the courts play in facing this existential crisis? All the while, courts have said repeatedly that they are ill-equipped to deal with this issue, or worse, refuse to address it at all. Some attorneys think the answer may lie in bringing class action lawsuits against big oil companies.
Tort law has supported successful class action suits in environmental fields before, but with respect to the particular problem of climate change, we're faced with some unique challenges. Understanding key aspects of tort doctrine can help explain why. A basic model for a successful environmental lawsuit might be the case of a company operating an unsafe oil tanker that causes a major spill along the coastline. The people harmed could join together and form a class action, since many of them have significant injuries and want to bring similar claims against the company. In this scenario, the plaintiffs could show the basic elements of a negligence claim. The company owed them a duty to not cause these harms, and by breaching this duty, it was the proximate cause of damages to the plaintiffs. Indeed, cases with these facts have happened before and have secured large awards for victims. Disasters, pollutions, and other blatant environmental transgressions are important, but don't scratch the surface of all the everyday emissions and industrial activities that exacerbate climate change over time. This is the reason for climate change litigation, which might focus specifically on the effects of climate change. But under U.S. tort doctrine, courts have difficulties handling these lawsuits compared to a simple oil spill. First, climate change raises issues of whether there was a duty owed and breached in the traditional sense. For example, a tort like trespass was designed to cover physical violations of property, but not things like emissions that are invisible, intangible, and diffuse. Second, tort law struggles to find specific parties responsible for climate change. This relates to the issue of proximate cause. When hundreds of major companies have played integral roles in releasing emissions, any one of them, when sued, can point to the others and argue there was no way to prove that it was specifically responsible. Third, who's allowed to bring forth a climate change lawsuit as a plaintiff? Plaintiffs must show standing to bring a lawsuit, which typically requires them to show that they have special injuries beyond the general public. On all of these matters, the law has tended to take a more constrained view, erring on the side of dismissing lawsuits for failing to state a claim, establish proximate cause, or lack of standing.
And indeed, almost this exact situation occurred in the case of Comer versus Murphy Oil. A group of plaintiffs, all residents of Mississippi and victims of Hurricane Katrina, sued a number of oil and coal companies. They alleged that the corporate greenhouse gas emissions exacerbated global warming, which raised the intensity of natural disasters and damaged the plaintiff's property. Courts dismissed the case, including claims of trespass and negligence for failing to establish proximate cause and standing.
In addition to the substantive limitations that tort doctrines present, there are also procedural barriers when bringing a climate change class action suit. Plaintiffs seeking to bring a class action must meet 4 requirements. First, numerosity. The class must be so numerous that simple joinder of all members is impracticable. Second, commonality. There must be questions of law or fact common to the class. Third, typicality. The claims of the representative parties must be typical of the claims of the class. And fourth, adequacy. The representative parties must fairly and adequately protect the interests of the class. We talked with Dr. Ben Franta about the difficulty of identifying a common issue of law or fact among the class of plaintiffs.
I think one of the challenges is with the impacts of climate change being different for different individual people, depending on where someone lives, depending on whether this person experienced a particular impact or not.
But it's not all doom and gloom. Even though federal class actions tend to be very difficult to certify for personal injury type cases, state class actions may be easier to certify. Even though the Class Action Fairness Act has made it difficult to certify state class actions, particularly multi-state class actions, because the removal procedures under CAFA would allow defendants to bring the cases back to federal court. Individual state-only class actions are a carve-out from CAFA, and states have been quite innovative in using the class action procedures under their own procedural rules to allow for significant use of the class actions even in personal injury type situations.
In other countries, climate change class actions have been successful. One notable example comes from the Netherlands with a claim based on a Dutch tort law duty of care doctrine. In May 2021, the Hague District Court issued a groundbreaking decision when it ruled that Royal Dutch Shell was required to reduce its worldwide CO2 emissions by 45% by 2030 compared to its 2019 levels. The class action lawsuit was filed in 2019 by Friends of the Earth Netherlands and 6 other Dutch NGOs alongside 17,000 other individual co-claimants. The complaint alleged that Shell failed to take sufficient measures to reduce emissions generated by its entire group, in breach of its duty of care to prevent dangerous climate change through its policies. The claimant stated that the duty of care was based on the Tortious Act provision in both the Dutch Civil Code and in the right to life and the right to respect for private and family life, which is enshrined in the European Convention on Human Rights. We think that there are plenty of bright legal thinkers taking a closer look at how the law can help, instead of actively prevent, making progress on climate change. We are excited to join them and plan for a brighter tomorrow, starting with making the corporations who got rich off exploiting the environment help pay for the damage.